Welcome to our guide on navigating a sudden inheritance and the legal traps that can arise when managing a deceased loved one's assets. First, we will set expectations. Access to money in the deceased's accounts does not mean it is yours to spend. Those funds belong to the estate until the law says otherwise. In this video, we'll walk through the essential first steps, clarify when probate is required, and outline how to avoid costly mistakes. Let's begin. Next, here is our roadmap. We will start with the essentials to secure in the first 72 hours. Then we will examine the Probate Reality Check and who is legally authorized to access funds. After that, we will cover legal transfers and why timing and documentation matter. We will also review veteran benefits that are often overlooked. Then we will compare what to do versus what to avoid, followed by a short quiz to reinforce learning. Finally, we will end with key takeaways and a summary of next steps. Before going further, please note this is educational content and not legal advice. Estate law is highly state-specific. You should consult a licensed probate or estate attorney in your jurisdiction for advice tailored to your situation. Now, when a loved one dies, you may uncover a bank account with a substantial balance, or hear about a large refund or benefit due. It is natural to want to move quickly, but doing so can create legal problems. Until the estate is opened and authority is granted, funds belong to the estate. Acting without authority may be considered fraud or theft. Let's see what to do first. First, secure the essentials. Order 6 to 10 certified death certificates as soon as possible because banks, insurers, and government agencies will require them. Next, gather all identification, account numbers, insurance policies, bills, and financial statements. Then, search carefully for a valid will. If you suspect a will was filed, check your local county probate court records. Meanwhile, start listing assets and debts to create a clear inventory. Finally, schedule a consultation with a local probate attorney who can explain state-specific requirements and timelines. Next, let's ground ourselves in the probate reality. First, confirm whether you are a joint owner or named as payable-on-death or transfer-on-death beneficiary on accounts. If not, you will need legal authority through probate or a small estate process. Then, open the estate by petitioning the court to appoint an executor or administrator. After appointment, you must notify creditors and comply with state waiting periods. You will pay legitimate debts and taxes before distributions. Only after receiving court approval or legal clearance should you distribute funds to heirs. Continuing, this timeline shows a typical estate administration. In the first 1 to 2 months, the family secures death certificates, locates the will, consults an attorney, and files to open probate. By months 2 to 3, the executor inventory is compiled and creditor notice is issued. Between months 3 and 6, the creditor claim period runs while the executor reconciles debts and preserves assets. Around months 6 to 9, the estate pays approved debts and any taxes and files required returns. Finally, in months 9 to 12, the executor petitions for final distribution, obtains court approval, distributes assets, and closes the estate. Timelines vary by state and case complexity. After understanding the timeline, focus on legal transfers. Do not move money out of estate accounts early. Keep accurate records for every transaction and retain receipts. Wait for court approval or other legal clearances before distributing funds to beneficiaries. Consult with a tax professional to address any income or estate tax reporting implications. Finally, document distributions with signed beneficiary acknowledgments to maintain a clean, auditable record. Moving on, let's compare best practices with common pitfalls. Do obtain multiple certified death certificates. Build a full asset and debt inventory. Open the appropriate probate or small estate proceeding. Notify creditors on time. Consult a local probate attorney. And keep accurate records using estate accounts only. Conversely, do not withdraw funds from the decedent's account without authority, do not make early or verbal distributions, do not ignore creditor claims or tax obligations, do not pay for services that veteran benefits might cover, and do not commingle estate funds with personal accounts. Next, this table summarizes which assets typically require probate. Sole bank accounts without a payable-on-death beneficiary usually require probate, because there is no surviving owner. Joint accounts with rights of survivorship and POD or TOD accounts generally pass outside probate by contract. Life insurance with a named beneficiary likewise pays directly to the beneficiary. Small estates under state thresholds may use simplified procedures, which vary widely, and can be up to around $125,000 in some jurisdictions. Real property titled solely in the decedent's name often requires probate to transfer title. Vehicles may transfer through a State Department of Motor Vehicles affidavit process or probate, depending on local rules. Continuing, if the decedent was a veteran, contact the National Cemetery or the Department of Veterans Affairs about burial arrangements and military honors. Many costs such as headstones or markers are covered, so verify these benefits before paying a private provider. In addition, inquire about any VA life insurance benefits, which are commonly missed. Coordinate with the funeral home to avoid duplicate payments. Keep copies of all documentation for benefits and reimbursement claims. Next, this mind map shows the main parties to notify after a death. Under Government, you will contact the Social Security Administration, the Internal Revenue Service, and the Department of Veterans Affairs if applicable. Under Financial, reach out to banks, creditors, and insurance providers. Under Services, notify utilities, subscription services, and phone or internet providers to stop or transfer services. Under Legal, contact the probate court and your attorney. Finally, inform family members and the person named as executor in the will. Now it's quiz time. The question is, you discover $60,000 in the deceased's sole bank account with no payable-on-death beneficiary. What should you do first? Option A. Withdraw funds to cover family needs, then sort it out later. Option B. Wait for probate or a small estate process and obtain legal authority. Option C. Transfer the money to a trusted relative to hold. Option D. Start distributing funds based on verbal promises. You may pause the video now to consider your answer. We will discuss the correct answer in the next section. The correct answer is to wait for probate or a small estate process and obtain legal authority. Funds in the deceased's sole account belong to the estate until an executor or administrator is appointed, or a small estate process authorizes access. Acting early may expose you to legal liability and complications. To conclude the core lessons, remember to obtain multiple certified death certificates first. Without legal authority, you cannot access assets. Probate or small estate rules apply. Debts and taxes must be paid before heirs receive distributions. Document every step and keep estate funds separate from personal accounts. If applicable, explore veteran benefits that may cover certain costs. Consult a local probate attorney early to avoid common traps and expedite the process. As we wrap up, secure documents, locate the will, and inventory assets and debts. Open probate as needed, notify creditors, and follow state timelines. Avoid early transfers and wait for legal clearance before distributions. Use veteran benefits when applicable. Work with a qualified attorney to protect both the estate and yourself from liability. Finally, thank you for watching. If this video helped you, please like, share, and subscribe. We would love to hear your questions or experiences in the comments, so others can learn from them as well.